They further, for the time, disclosed the text messages between her and Detective Maynard that I asked her about. What's in these text messages should have been available. I used this on cross-examination. It's different than what she testified to. This is giglio that was not given to us, and we moved for a mistrial.
Okay, pause. So you're calling it giglio information because you believe it is information that is material to impeachment of one of the state's witnesses?
Yes.
Okay. And do you have any basis to say that the state had it before Ms. Lauper was put on the stand?
Well, this was information that we requested. It was information we requested when we tried to get.
Answer my question.
Yes, it belonged to Detective Maynard. Detective Maynard had this information and sent an email to Mr. Bloodworth about the violation prior to the trial starting.
Mr. Bloodworth.
I'm not entirely sure what text message this defense received this morning. It was not from me. I had not heard of it until just now. I understand that about 10 days ago, the defense submitted a grandma request to the sheriff's office asking for information related to the supervision of Carmen Lauber.
By Mr. Maynard.
They asked for any information on all supervision.
Okay.
The supervision was by Eric Maynard.
Yeah.
I think they're referencing a violation of probation involving she was caught with an alcoholic beverage. Is that what we're talking about?
That's correct.
I provided that information to defense maybe 3 weeks ago in an email.
Okay. Ms. Lewis, I'm not going to shoot from the hip on this. You'll have to put this in a written motion so I can see it all with the timeline and let the state respond to it.
Yes, I can. I will just state for the record, the email about the alcohol violation was sent to Mr. Bloodworth November 15th of 2023.
Well, but what about Mr. Bloodworth's email to defense that he just referenced?
I saw no such email.
Okay, well, we'll get into it, but you've got to put this in writing. We're not going to do this on oral representations in the moment.
Understood.
Okay. Anything else on that?
Not on that, no. Do you want to address anything?
Do you have one other issue, Your Honor? I know that it is always tradition that the state gets to sit closest to the jury in every trial I've ever been in. That's the case, and we actually prefer it that way. But we are getting reports from individuals who are watching this matter on television that particularly yesterday, but also previously to yesterday, that members of the prosecution team are making faces at the jury during our cross-examinations, and we would ask that
With respect, I have a better view of this than any of the cameras. I haven't seen anything like that.
Okay, well, we've asked for the timestamps, and we're going to try to provide it to the court, but all I'm asking is just a gentle admonishment that that's not appropriate and to try to refrain from doing that to the extent that is happening. Also, the second concern that I have is when Mr. Bloodworth is tendering the witness to the defense, he's making a statement that I believe the defense will have questions for you. We do believe that's, I'm sure it's not intentional, but it's burden shifting, and we would ask that he not make that statement at the conclusion. We're not required to ask them any questions. So we would just ask that that no longer be stated to the witnesses in the presence of the jury.
Yeah, as a matter of law, I don't view that as any instruction to the jury or comment regarding burden shifting. If you stand up and say you have no questions, you have no questions. I'm not going to admonish anybody for anything that isn't happening. The only faces I've seen are counsel at me. And so I think we're well within the proper bounds of appropriate conduct from what I can see from here.
Right.
Anything else?
We'll submit it in a motion, Your Honor.
Okay. All right. Mr. Bloodworth, anything before we invite the jury in?
No, Your Honor.
Okay. Mr. Ramos, you ready to go?
Yes.
Okay.
Yes.
Mr. Burmester, the stay. Oh, sorry. May we invite the jury in, please?
defense doesn't have any objections to the exhibits coming in through Ms. Coates.
Got it. Okay. We'll just need to create a record in real time. Please have a seat as you come in. All right, have a seat. Mr. Burmester, the state's next witness, please.
And Kouri.
Ms. Coates, if you would step in front of Brittany, we'll get you sworn in, please.
You'll raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Please have a seat.
Please proceed.
Thank you. Can you please state your name and spell your last name for the record?
Ann Coates, Coates.
Ma'am, are you employed?
Yes,
By whom?
CMFG Life Insurance Company, also known as True Stage.
I see. And what capacity do you serve them?
I'm a senior manager in the claims department for our consumer claims.
And have you been there how long?
Almost 23 years.
True Stage is an insurance company,
Yes,
and is True Stage associated with a particular business?
yes. We offer insurance through credit unions,
I see.
mostly.
Any particular credit unions?
A wide variety of credit unions throughout the
Right.
United States.
I see. PenFed being one of them?
Yes,
Okay. And so, did you receive, can we see 7-21, please? Did you receive a application, a written application for an insurance policy from allegedly Kouri and Eric Richins?
yes,
Okay. Do you see State's Exhibit 721?
I do.
State would offer State's Exhibit 721.
Okay. State 7-21 is admitted.
Okay. In here, the author or authors have listed a mailing address.
Yes,
Can you, is that the P.O. Box 759?
it is.
Okay. And is there a phone number for Eric Richins?
Yes,
Could you state that phone number, please?
it is 801-892-9317.
I see. Okay, was there any email address given for Eric Richins?
No.
Okay. Now, can we scroll down just a little bit? At some point, does this application connect to a method of payment?
Yes.
Okay. Can you go to the last page there? So this application gives, is this for an automatic withdrawal?
It is.
Okay. And the account number given?
It's ending 6577.
6577.
Yes.
Okay. Thank you. Now, it's purportedly signed by two different individuals, Kouri and
Yes.
Eric, there at the bottom. Okay. Let me go back up to the top, please. Is there a place on this form for a social security number?
Yes.
Where?
About halfway down.
On the front page?
Yes.
Okay. Okay. And in this case, it's been redacted?
Yes.
Okay. Do you remember today anything about that social security number?
I do. Eric Richins' social security number, the last 6 digits are transposed.
I see. Okay. And, once this, do you know when this application came in?
We received this application on February 3rd, 2022.
And when was it approved?
On February 4th, 2022.
Okay. And did any sort of notice go out to the owner, to, for example, Eric, to let him know?
Yes, we sent a billing statement confirming that there would be an automatic withdrawal for the premiums,
Can we see States Exhibit 722, please?
and then also a welcome letter with the contract.
I see. Is this the welcome letter you're talking about?
Yes,
Okay. And in this, does it indicate where it was mailed to?
it does. P.O. Box 759 in Camas, Utah, 84036-0759.
Not 282 Willow Court?
No.
Okay. And this is an automatic withdrawal?
Yes,
And that's what this, Eric is being notified, it's going to be an automatic withdrawal?
yes,
And out of this account, 6577?
yes.
And when will that initial deduction come?
The first deduction, we were notifying him would come on February 14th, 2022.
Okay. Now, did Eric Richins have other policies, any other policies besides this one we've just been talking about?
Yes,
Okay. Wasn't there a policy of accidental death and dismemberment policy,
yes,
ultimately valued at $300,000?
that's correct.
Okay. And there was another policy issued June 9th, 2017?
It was actually issued May 12th of 2017.
Backdated to that day?
Yes, backdated.
Why that day?
I believe that was the day before his birthday. And we do that sometimes to, we call it to save age and to save on premium.
I'm sorry, Your Honor. Can we publish 722, please?
Any objection, Mr. Ramos?
No, Judge, thank you.
722 is admitted and published.
And we've highlighted the mailing address, the account, and the first date of withdrawal.
Yes,
Okay. All right. So going back to this second policy, the two it was a $250,000 policy, life insurance
Yes,
on Eric Richins' life.
that's right.
And that policy, do you know how it was being paid? From what account?
I would like to refer to the application, if you have that.
Okay. Would that help you refresh
Yes.
your recollection? May I approach the witness, Your Honor?
Yes, sir.
Do you recognize that?
I do.
What is that? Just for
This-
the record.
Is an application for insurance.
Okay. You can just examine it for a moment. Does that help refresh your recollection?
It does.
How, by what account was this taken? The payment's taken, I guess.
Yep, sorry, just one moment here. The account number is blacked out on the one page, but it says on another page here, checking account ending in 2204.
Okay, so. Thank you.
Mhm.
Is that the welcome letter like you talked about on?
Yes,
Okay. Then there's this policy. Now, how does one make a claim? Or how is it initiated, I guess?
yeah, there are several ways that we can accept a claim. A lot of times it's by phone from a family member or beneficiary. In this case, what we do is twice a year in the state of Utah, we would run our policies up against a Social Security death master file list.
Mhm.
And that's how we found that he passed away.
Okay,
And that was done in April of 2022.
okay. So this policy, we talked about the accidental death and dismemberment.
Yes,
Was that ever paid out?
that was not.
Okay. Because it wasn't an accident or dismemberment.
That's right.
Okay. So then the policy, the $250,000 term policy,
Yes,
was that ever paid out?
it was.
Okay. Let's take a look at 7-12, please. Do you recognize 7-12?
Yes.
And what is that?
This is proof that we made the payment.
Okay. And how was that payment made?
This payment was made by check.
Okay. In the amount of $251,558.82?
Yes.
Okay. And it's a $250,000 policy. Why that difference?
There was a partial premium refund and state interest that was added to the 250,000.
Okay, can the statement has to offer and publish here.
No objection, Judge.
States 7-12 is admitted.
That was sent out, when did you say?
This was sent out June 17th, 2022.
I see. Okay. Now let's talk about the. Is there a way in which a policy owner or a beneficiary can communicate with True Stage, and a record is kept of that communication?
Yes, they can call us or email us at any time, and we keep a claim log for every call or every transaction that's made.
Okay. Those things are called claim notes, right?
Yes,
Okay. Can we take a look at 7-11, please? Do you recognize that?
yes,
Is that one of the claim notes?
it is.
Okay. And it looks like 220 state would offer states exhibit 7-11.
Okay.
Permission to publish.
7-11 is admitted.
There's a number at the top. In this case, 2204 22032.
Yes, that's the claim number.
Okay. And that represents the year 22. 04 is the month,
Yes,
and then 22 is the 22nd day of that month.
yes,
And this happens to be the 32nd claim made that day.
yes,
Okay. So this one occurs, the claim is initiated on April 22nd of 2022.
yes.
Okay. Then let's take a look at also 7-23, please. State would offer states exhibit 723.
No objection. State 723 is admitted.
Ask for permission to publish. In this case, the claim is initiated on April 28th of 2022.
Yes.
Okay. Initially, at least, is one claim for a particular policy or another,
Yes.
but over time, do they kind of bleed into the same one?
They do. Any action taken on one claim is noted on the other claim as well, so that we can provide the best service to our beneficiaries as possible.
Okay, so I'd like to focus in on this one for a bit here. On April 28th, is there a discussion between, I guess this column that says desk and has some codes, is that who the person is from True States that happens to be talking that day?
Yes.
Okay. So on April 28th, is there a discussion between Kouri Richins and True Stage?
Yes.
And in this particular case, they're talking about both policies, aren't they?
Yes.
Okay. That is the policy, the $250,000 policy, as well as the more recent $100,000.
Yes.
Okay. Then on May 4th, is there another communication in this notes with Kouri Richins?
Yes.
What's happening in that communication?
We received a call from Ms. Richins, and she wanted the status of the claims. And so we provided the status and informed her that we received a pending death certificate, but we would also need the final death certificate.
I see. And in this case, the person taking these notes is saying DC, meaning death certificate.
Yes.
Okay. So it's still pending. So on June 7th, another communication
Yes.
involving Kouri Richins.
Yes.
So in June 7th, does True Stage receive the death certificate?
We did receive the final death certificate that day.
And what does it say the cause of death was?
Drug intoxication, fentanyl.
Okay. So on June 14th, does True Stage talk to Kouri Richins about they now have a death certificate?
Yes, we did.
And so what is the question of Kouri?
The question was if the drug fentanyl was prescribed to Eric Richins. And that's important because the $50,000 accidental death benefit rider as well.
Excuse me, just one second. That extra 50,000 is
Extra.
on top of the $250,000
Yes.
policy.
Yes.
Okay, go ahead, continue. I'm sorry.
It provides an provision and an
Mhm.
exclusion where the prescription would need to have been provided by a doctor and administered on the advice of a doctor in order to be payable.
Okay, and the person writes some notes about what Kouri Richins told them.
Yes.
Okay, and what does Kouri Richins say?
She said that the fentanyl was not prescribed. And she also added that she doesn't know how her husband got that.
Okay. The next day, Kouri Richins called again.
Yes.
Okay, and what was stated in that conversation?
It was the same thing that she provided us, that the drug was not prescribed
Okay,
and that she doesn't know where it came from.
okay. On June 21st, did she call again
Yes,
and asking about a status?
she did.
And what did you guys tell her?
We told her that the $250,000 claim was paid, but the most recent claim, the $100,000 claim, was still being reviewed.
Okay. And why was it still being reviewed?
That was a brand new policy, and so whenever we have a death that occurs within 2 years of the effective date of coverage, it becomes a contestable claim, which just means that we will review the application questions and the insured's medical history to be sure that the answers were accurately answered.
Okay, so all you're looking at is, once again, medications and answers to medical questions on the application?
Yes,
Okay. And because this was 1 month.
right.
Okay. Did ultimately True Stage pay on this claim?
Yes.
Do you know when and how that went out?
Yes, it was August 31st, 2022, and we paid that by electronic funds transfer into an account of hers.
Can we see 725, please? Can you tell us what 725 is?
This is confirmation of the payment.
Okay. State would offer State's Exhibit 7-25.
Okay. 725 is admitted.
Okay. So you said this one was an electronic funds transfer
Yes,
as opposed to a check.
that's right.
Okay. Now, in this document here, is there a second page?
Yes.
Okay. Can you keep? All right. Do you know where this electronic funds transfer, what account that went to?
I do. Could you go back to the first page?
Okay.
To an account ending 2204.
Okay. Now, it was being paid from 6577. Can we look at State's Exhibit 710, please? 710, please. I'm sorry. Speaking so low. This is a communication from Kouri on that $100,000 claim.
Yes, this is her claimant statement that we have our beneficiaries complete on all contestable claims.
Okay. And so the state would offer State's Exhibit 7-10.
No objection, Judge.
State 7-10 is admitted.
Page 2, if we could focus in on that. What is displayed here?
This is a voided check that she provided, providing the information for the checking account that she would like the funds put into.
Okay, and that's the account 2204.
Yes.
Okay. And finally, back to, I think that was States Exhibit 7-23. On September 8th, was there another communication, either email or phone or something from Kouri Richins?
Yes. She emailed us and asked if there were any other policies, and we replied that there were the 2 policies that we paid.
Okay. I have nothing further for this witness.
Mr. Ramos, please.
Thank you, Judge. Good morning, Ms. Coates.
Good morning.
How you doing?
Good.
Could you kind of walk through, when we were on the phone, you kind of explained to me how your company sends out insurance, I don't know what to call them, applications throughout the year. Could you explain that to the jury, please?
Yeah, we send out insurance applications in the mail to credit union members as well as other individuals now. We send it to everyone. And if they get one in the mail, they can fill it out and send it back in.
How often do you guys have a schedule for those to go out every year?
I'm not sure of the schedule.
Do they go out more than once?
I
Or
couldn't
if you don't
say.
know, that's fine. No problem. Now, could you explain a couple of things with regards to the different life insurance policies or term life insurance that have that are at issue today? Could you kind of just walk me through those one more time from the earliest to the most recent? You had mentioned like a 2017 one, I believe.
Yes. So there was a policy taken out effective May 12th, 2017 for Eric Richins.
And who took that out?
We received an application with the assumption that he took that out.
Okay, perfect. And then which one was the next one?
The next one is the most recent, which became effective February 4th, 2022.
And was that the February 4th one? Was that one a part of Miss Richins calling out and saying, hey, can I get life insurance? Or was this in response to that mailer?
This was in response to the mailer.
Okay. And the address that you received, the P.O. box that Mr. Burmester asked you of, if we could go back to, or if you recall it, the P.O. box, you recall that one?
Yeah, I don't remember the exact
No
number
problem.
of
But
it.
we'll pull it up. I believe it was.
Yes. If we could publish to the jury as well, this has been animated, Your Honor.
It's not. There we go. One moment. Go ahead.
Perfect. And so as you can see on the applicant information side, as well as the spouse or partner information, the P.O. box address is the same, correct?
Yes,
And it's already pre-filled.
it is.
Okay, so that information you received from the credit union?
Yes.
Okay, can we take that down? Now, in this case, you received would you do a script check score?
Yes,
And did you do that in this case?
we did.
Okay. And when would that have been done?
That is done before the application is approved or declined.
Okay.
And then also we do that at the time of claim.
Perfect. And so when you approved it, you indicated that you received it, I think, the 3rd, and then it was approved the next day or within the next day. Is that correct?
Yes, we received it on February 3rd, 2022. And then the script check would have been done and approved on the 4th.
Okay. And what is there anything in the script check that would have resulted in it not being approved?
No.
Okay. Now, if we can go to States 723 and just on the 27th of April, which would be, I think, the second page. Next, is that February 27th or
Yes.
April 27th, I mean?
Yep.
Okay. So on the top there,
Show this to the jury, Mr.
sure. That's great. Just to get clarification, the first line there, LexisNexis, primary Benny, and then it goes, before it gets to the second one, it goes obituary not found. So could you walk me through how did you guys receive notice of Mr. Eric's passing?
Yes. So twice a year in the state of Utah, we run a match up against the Social Security Death Master File to see if any of our insureds have passed away. And he came up in this instance. And what we do is we use LexisNexis to match and find the beneficiary and make sure that we have the correct person.
Okay.
And then the obituary at this time, when it was noted, was not available online.
Okay. Understood. We could take that down. Now, the P.O. boxes that we saw, you just received those from the credit union. You don't have any knowledge about who has access to those, right?
No.
You assume, obviously, that the individuals you're sending out the mailer is going to get the mailer you sent out, correct?
Yes.
And in this case, they did, correct?
Yes.
And it got returned to you, correct?
Yes.
Okay. And when you we saw lots of applications as well as the approvals of the money going out. Mr. Burmester at the beginning, I believe, used the word allegedly filled out by Ms. Richins. You assume that whoever's sending it to you received it from whichever P.O. box or mailing address you sent it to, correct?
Yes.
You have no reason to think it would be anybody else, correct?
Correct.
Okay. And I imagine you guys don't do some sort of expert handwriting certification or handwriting comparison when you receive the application.
No.
Okay. When you receive the application, in this case on February 3rd, do you call the individual who submitted the application, or does it automatically just go into the process of being screened?
We don't call them. It just goes into the process of being screened.
And is that an individual doing that, or is that automated?
It's an individual that inputs the information into the computer, and then the computer will run the script check.
Okay. And then I imagine some sort of AI or something checks if anything pops up and then spits out, yes, we're good to go.
Yes.
Okay. And in this case, before the life insurance was paid out, your office sent out requests for medical record
Yes.
for Mr. Richins,
Yes.
and you received those back, correct?
We did.
And in there, you did highlight anything or identify anything in terms of prior drug use, correct?
That's correct.
And in this case, marijuana came up, correct?
Yes.
Okay. I have one moment. I think those are all the questions I have.
Okay.
Now, this application that we have here, and if we could publish this to the jury, it's been admitted, Your Honor.
Is it 7-21?
No, I apologize. Yes, Judge, 721.
One moment. Go ahead.
this application is both for Kouri and Eric, correct?
Yes,
They're both on it.
that's right.
That's all I have. Thank you, Ms. Coates.
Couple questions. Do you recall in those medical records the stated frequency of use of marijuana?
Yes, it said once or twice per year.
Okay. And then when you did your script search, I don't know why I'm having trouble with that. It's a check for prescriptions prior to approving the application. Is that
Yes,
fair? And did you get an answer when you did that search?
the answer was that there were none,
No prescriptions
no
at that point.
prescriptions.
Thank you.
Oh, sorry, no further questions. Thank you.
Counsel, may we release this witness?
Yes.
Yes, that would be the state's request.
You're free.
Okay.
Thank you.
Thank you.
Please watch your step. Ms. Sherbanek, who's next?
Christina Miller.
Ms. Miller, if you'd step in front of Brittany, we'll get you sworn in.
Put me all the way on the stand.
If you'd stop here briefly.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? I do. Thank you. Have a seat.
Please have a seat. Ms. Sherbanek, please proceed.
Yes, Your Honor. Good morning, ma'am.
Morning.
If you could state your name and spell your last name, please.
Christina Miller, Miller.
Ma'am, what do you do for work?
I am a divorce attorney, special master, private guardian ad litem, and just started doing divorce mediations as well.
How long have you been a divorce attorney?
Almost 30 years.
And in that practice, do you do exclusively divorces?
I do.
And do you have experience with custody arrangements?
Extensive.
In your practice, how many divorce actions would you say you've been a part of?
Over 2,000.
How do you get new clients in your practice?
In this town, word of mouth, typically. I haven't really ever advertised. We've done some hometown parades back in the day, but was really more for team building, office building. I don't advertise in the newspaper or radio or anything like that.
And I didn't ask you this, and I should have, but what geographic area do you typically practice in?
Typically Park City, Wasatch County area. On occasion, I'll have cases out in the basin. Sometimes I have to go down to Salt Lake, not often, but I have some people who won't take no for an answer with leaving some in Wasatch County.
Understood. And so tell the jury a little bit about your process when you take on a new client, what happens in your office, and then eventually how you get involved with that person.
So we have I think I'm a bit unusual as divorce attorneys go. We have a very strict process that we have developed, we being me and my paralegal, Leslie Staples, who's been my paralegal for going on 28 years now this March. And we determined pretty early on in our practice that there was a lot of information we needed to receive from clients in order to get a case going. So I developed forms that we use in every single case. When I'm meeting with client, I've developed diagrams. In approximately 2008 is when we really started putting things together so that every client meeting could follow the same pattern, the exact same order for the most part. And I could take all of that information, hand it to my paralegal, and she would know as much as I did at the time with regard to some basic information.
So if a new client was being referred to you, would they first set up a meeting with your paralegal via phone?
Yes. she has vetted clients since we started practicing together. If I vetted all clients, I wouldn't get any work done.
And so after that call with your paralegal, do you meet with the new client?
If they get past Leslie, then yes, she will schedule a meeting for me. Almost every new client, especially if they're at the beginning of a divorce case, she tells them that the meeting can be anywhere between 2 and 4 hours, depending on the complexity of their case. Like I said, my process, I think, is pretty unusual because I try and get as much information as the client knows or can give me, and I give them back as much information as I can to make that initial meeting really impactful because it's getting divorced is a very emotional process in addition to a legal process.
And so during that, or I should say, after you have that intake meeting, this extensive meeting with a prospective client, new client, or with a new client, how many people actually, in your experience, proceed from that meeting to filing a divorce?
Based upon my 30 years, almost every one of them. There are a handful that don't, but the process of emotionally, psychologically, finally calling a divorce attorney and then the process of showing up for a meeting is significant for most people. Once they've kind of hit that stage on an emotional, psychological standpoint, they're ready to move forward or ready to prepare to move forward. So, I mean, there have been people I've been meeting with for 10 years who have yet to move forward, but there are rare, it's rare that they don't move forward, either with me or someone else or something happens.
And in those rare occasions, what are some of the reasons that those people give or that you experience that they don't move forward with a divorce?
It's pretty specific to each individual client who's not moving forward, but the top reasons are they're concerned about kids, the impact of divorce on kids. They're concerned about the age of their kids and being too young to be able to speak up about what's happening in both households. Some people are concerned about their religion and what it means for them from a religious standpoint. Some people have stayed together for quite some time because of health reasons. Back in the day when it was more difficult to get insurance, you would have some people who had a significant health issue who stayed together until that health issue was resolved.
And so you've kind of talked about this extensive first meeting that you have with new clients. And part of that, it sounds like, is information gathering from that person. Is that correct?
Yes.
And you've talked a little bit about the forms that you go through. Are one of those forms directed towards, or the topic of that is any children involved?
Yes. So my office staff, I'm sure, gets annoyed at the fact that I like to have all my forms in a very certain order. And like I said, I'm a visual learner. That's how I teach people about divorce. So I have the diagrams I have and what I call the blue sheets, which are sheets that have all topics on it that I feel like I need from most divorcing people. They go in a certain order. So my packet, when somebody comes in to meet with me, it's thick and it goes in order. So it's first, what is divorce and what does this path look like? Then it's kids, and I have forms and booklets and reading material and the Children's Bill of Rights that we go over. And then there's assets and debts, and then it's ongoing issues. So if alimony may be a concern, we go over a diagram for alimony and hit a lot of topics on income, expenses. Then there's miscellaneous, and then we go over what does this path look like if you went this way? How do you tell your spouse? How do you prepare for ultimately filing or defending?
I want to turn your attention to Eric Richins. Did you know him?
I knew him in the sense that I met with him.
And how did you come to meet with him? Who referred him to you?
Several people, but the person that reached out to me was his brother-in-law, Clint Benson. He texted me in early October 2020, asked if I could meet with his brother-in-law, Eric, and told me it was urgent. So I explained the process that you have to get through Leslie. And I believe he contacted the office early October 2020. And I ultimately met with him October 23rd, 2020.
Okay, so Eric went through the process that you've described and ultimately ended up with you in that extensive new client meeting that we've been discussing.
Yes, we met for 2.5 hours.
While Eric was with you in that meeting, did he fill out the typical paperwork? Did he go through that packet that you've been describing?
Yes,
Okay.
he left the packet at my office. He didn't take it with him. We have a bound binder, for lack of a better word, that people take this packet of information home with them and read it. Eric did not.
Okay, give me just a moment.
This is our state's exhibit 8-49. If you could turn to the 8th tab.
Okay,
Do you recognize that?
I do.
And we've been talking about paperwork that Eric filled out. Is that some of the paperwork that he filled out in your office?
Yes. That, just so you know, under adverse party, where it says Kouri, Richins, Darden in parentheses, that's my handwriting, and it's my handwriting at the bottom in the kind of grayed out box.
Okay, and the rest of that is paperwork that Eric filled out.
Yes.
Okay, that's all we need from that one for now. So I want to talk about the advice that you gave to Eric Richins during this meeting. Did you get an impression about why Eric was in your office?
I did.
What was that impression?
He was there to find out what it would look like in terms of going forward with the divorce. Was there to learn how to protect his finances, having just...
I'm going to object.
Pause
This
there, Ms.
information
Miller.
is all based on hearsay.
Are you asking about her observation of his physical
I am not
demeanor?
on camera. I'm actually not.
I'm asking about effect on the listener, Your Honor, how his information informed her legal advice.
Please approach.
Wild.
During your meeting with Eric, did you give him legal advice about custody?
I did.
Describe in 2020, what was the presumption when someone was contemplating divorce about how custody arrangements would work?
At that time, well, let me start with when I first started practicing, way back when. It was the old Ward and June Cleaver thing with regard to custody. Somebody had most of the time and the other person had weekends. There has been a wave through the legislature, through child psychologists, with regard to child psychologists focusing on what's in the best interest of kids, and the legislature listening to lobbyists. I was on the executive committee for the family law section of the Utah Bar at the time, so we closely watched what was going on in the legislature. So at that time in 2020, there had been a statute passed about 5 years previous that finally had an alternative parent time schedule that was more of a 60-40 type schedule. We called it fat weekends, but that is where courts were going. Courts, judges, custody evaluators were all trending towards equal parent time, 60-40 parent time, and so forth. So by 2020, this was October, there were already rumblings of a new statute being passed that would be an alternative statute for 50-50 parent time. That all these statutes have been renumbered in 22, but at that time that was 35.2 or going to be 35.2. But when I met with Eric, we had 35.1, which was this fat weekend. So I talked to him a lot about this is typically what happens with kids and going through a divorce, unless there is something really that stood out. Almost all judges were going with more of a joint physical custody situation.
And so you explained that potential situation to Eric Richins.
Right off, yes.
And without saying if he had a verbal reaction, could you tell how he reacted otherwise?
Yes, we had no further discussion about custody or all of the other things that would go with custody, where I would typically get into with clients specifics about what holidays look like, what a full year calendar looks like, whether there are meaningful holidays in their family, what the right of first refusal looks like. I have on my blue sheets, it's 2 pages, and I would, in most cases, I fill out both of those pages.
Did you do that with Eric Richins?
No, I didn't.
Was that unusual?
It is unusual. It is unusual for me not to continue down the path of a custody conversation, and it typically means that, well, in every case, I think that I haven't filled that out. It meant the client did not want to think about, for whatever reason, did not want to think about the possibility of not seeing their child every day, or the possibility of the other side having their child more often than them or an equal amount as them, and so forth. But
at the conclusion of your intake meeting with Eric Richins, did you give him a to-do list?
I did.
And when you give a client a to-do list in your practice, does that mean that a divorce is imminent?
Typically, yes. I've been around a long time, and this is a small town, small county. And so there are people that will come and meet with me to try and conflict me out of a case. And after so many years of practicing, you learn pretty quickly that that's their intent, because they want to take our 3 or 4 hour meeting and do 15 minutes and call it good. Some of those people retain us. Others just want to know the information that I have, because, like I said, I'm trying to teach them all about divorce and what life looks like after divorce. So
giving the to-do list, how is that significant in your practice? Would you give that to someone who wasn't going to proceed?
No. if I have somebody that comes in and they're either trying to conflict me out or they just really want to talk about what this might look like in 30 years down the road, there's no to-do list. Sometimes I won't even fill out the questionnaires that I have, the question papers, the blue sheets. But if they have a to-do list, people are, in my experience, it is anticipated that they are going to file for a divorce at some point in the future.
And Eric walked out of this meeting with a to-do list from you.
He did not want to take it with him.
Oh, that's right. He didn't leave it, but you gave him a to-do list. Is that right?
He wanted me to correspond through his brother-in-law, Clint. So I emailed the to-do list to Clint.
Did you refer Eric Richins to anyone after or during your meeting with him?
I did.
Who did you refer him to?
He had worked in the past with Crystal Bowman Carter to do his business planning documents, and he needed to revoke a power of attorney. So he was going back to Crystal for that, or I told him to go back to Crystal for that, and also to redo an estate plan.
Okay. Was it unusual in your practice to refer someone in Eric Richins' position to a lawyer like Crystal Bowman Carter?
Yes.
Why is that unusual?
Because most people going through a divorce, in my experience, aren't thinking beyond what that divorce might look like. They're not thinking about death or estate planning and so forth. And most people, once you file for divorce, you cannot change any beneficiary and so forth. And so that was not a rule at that time in 2020. It's a rule now, but it was unusual. I've only referred one other person in my memory to change their estate plan while a divorce was either pending or before they filed for divorce.
So Eric went through this initial meeting with you. Did he ever file for divorce with you?
He didn't.
Or through you, I suppose?
No.
And did you discuss a timeline with him about filing for divorce?
I did not discuss a timeline with him. As I said, well, I didn't say this, but because divorce is so emotional, and there are so many things to unravel, kids and finances and debts and family and external family and extended family, and everybody really is on their own timeline. Like I said, I have a couple clients currently that I've been meeting with them for 10 years off and on. So they're not ready to pull the trigger, and everybody has a different timeline.
Thank you. Those are all my questions for you.
Good morning, Ms. Miller.
Morning.
My name is Wendy Lutz. I am one of Ms. Richins' attorneys. So I think you stated on direct already, but it wasn't Eric Richins that reached out to set up an initial appointment with your office, correct?
That's correct.
It was his brother-in-law reached out, and not just to say, hey, I'm referring someone to you, but he reached out to set up the appointment, correct?
I don't recall whether I wouldn't have been part of that conversation. That would have been with Leslie, my paralegal.
Can we take a look at CM1, just for the witness? Let me see if that's the right one. Okay. Let me just ask another question before we talk about that document.
Sure.
Two more questions. So you do remember that it was Mr. Benson that reached out, and then you set up a meeting with Eric. Did anyone attend that meeting with Eric, or was it just yourself and Mr. Richins?
It's my understanding Eric contacted my paralegal to give her a lot of specifics about his situation. And then the meeting that I had with him was just the two of us.
All right. And after that meeting, it was Mr. Benson that reached out and thanked you for meeting with Eric, correct?
Yes, Eric did not want me to have any contact with him via phone or email directly. He wanted everything to go through a third party, his brother-in-law.
Okay, that's what I was getting to. So when you gave Eric the list of documents, you actually sent that to Mr. Benson.
That's correct.
And then it was actually Mr. Benson who provided you with the documentation over email. I don't know, Eric may have brought some things in person, but anything that came over email was between you and Mr. Benson, correct?
Correct.
And would one reason that a client would ask for that, would it be because they weren't ready to let the spouse know that they were considering divorce? Is that fair to say?
Yes.
All right. And a reason for this, and I mean, I know you said that most people who come in and go this far do end up filing for divorce, but fair to say that some people aren't certain if they're going to file when they come in to see you, correct?
Very few.
It happens though.
It does happen, yes.
All right. And you testified that you went through custody arrangements with Mr. Richins, correct?
Yes.
And you went through the forms you went through regarding children involvement in divorce, correct? I might be naming that form wrong, but you said you went through forms about children.
Children's Bill of Rights.
The Children's Bill of
Yeah,
Rights.
it is not an official thing in Utah, but I have it and I give it out on it. I'm very color coordinated, so I've colored pens for various things, colored paper for the initial client consultation. That happens to be on purple paper, and it's taped up all over our office as well, so I can remind clients, this is the sun, your kids are the sun, and we are all rotating around them. So let's keep our eye on the prize. So it's just, it isn't anything you could enforce in court, but it's something that I like to share with clients.
Sure, because clients with small children, that's a huge consideration, is what will happen with the children, both financially and emotionally, and who the children will be living with, fair?
Typically not financially, but emotionally and who they will be living with and what the possibilities are for sure is a big concern for most people.
Okay. Finances are a concern, which is why you fill out a child support form with clients, correct?
Yes.
And can you pull up CM 5? And you filled out a form with Mr. Richins about child support, correct?
I did, yes.
And he reported to you at that time his monthly income was $33,333, correct?
That based upon what, yes.
Okay.
Sorry, I was gonna say, I didn't have documents at the time, so we were just, this is more for kicks and giggles of this is what child support would look like if this were the number.
Fair.
Yeah.
And his child support was going to be high, correct? Based on his income.
Yeah, well, I mean, it depends on who you're thinking about. In Park City, probably
You're
not so much,
absolutely
but
correct.
for most people,
That's
yes.
true. In my very small dalliance with divorce law,
Yes.
you see people whose income it's quite low. I'm going to say frequently. Some people it's quite low and child support's not very much.
You can have that for sure.
And for some people, this is a lot of people. $33,000 a month is a high income, correct?
Not for a lot of people that I deal with, but I think on the whole,
fair.
yes.
All right, you're dealing with some more, maybe fair to say that didn't come out very well, high-end clients, high-end divorces with more assets.
I would say the longer you're in practice, the more difficult your cases become, and the higher the wage tends to be with regard to divorces.
Okay. Now, other things you discussed with Eric were assets.
Yes.
Fair. And you were made aware that he was a partner in,
Objection, Your Honor.
I'm just asking if she's aware.
Forgive
May
me,
we
what's the
approach?
basis of the objection? Sure.
It's hearsay.
Okay.
Interesting during this little sidebar. This seems very long and belabored part of the testimony, and it just seems like they're looping around a lot of the same topics here. I have to say this judge seems very fair, though.
So in consulting with Mr. Richins and receiving documents from Mr. Clint Benson and maybe from Mr. Richins, you became aware, or were you aware, that Richins owned a couple of businesses?
I became aware of that during my conversation with Eric.
Did you become aware of that in any way through documents, tax information provided, other documents provided to you by either him or his family?
I did not receive any tax returns from Eric Richins.
Did you receive anything, documentation in terms of his businesses?
No.
Can
You mean
I,
the business specifically?
yes,
No.
or that the businesses existed?
Yes,
Documentation that the businesses existed.
correct.
Okay. And one of the businesses was C&E Stone Masonry, correct? Do you recall that?
Yes.
And Katie, can you just pull up? Good question. The next one. I think it's maybe CM6 or 8. I don't know. Help me out here.
What page was it?
Here, one moment, Your Honor. I apologize. Just one moment. And if you could just plug just for the witness, CM7. So you became aware that he owned partner in C&E Stone Masonry, correct?
Yes, so this document.
Well, that's just to refresh your
Oh,
recollection.
got it. Okay.
Okay.
Yes.
And you also became aware through,
I need you to ask the question to lay foundation for the how about the other businesses
I was about
as
to.
we discussed. You
Oh.
can't ask it as a leading question.
All right. All right. Let me back up a little bit. You said through documentation, you became aware of Mr. Richins' businesses, just that they existed.
The masonry business.
Did you receive documentation that he and Kouri Wright were also partners in another business?
No,
You did not receive any documentation about any businesses existing, just the existence of businesses.
Asked and answered.
No.
Okay, well,
Overruled. Now we have double confirmation. Please go from there, Ms. Lewis.
okay. Did everybody hear the whole?
I think it was 2 no's in a row.
Okay.
But
All right. Let's see. So now, I know Ms. Sherbanek asked you, and you said it was true that Mr. Richins did not proceed with divorce in this manner, in this case,
not
correct?
prior to his death, no.
And to your knowledge, he did not proceed with divorce with a different attorney, fair?
Correct.
All right. And you said that you referred him instead to an estate planner, estate attorney.
Didn't
An
refer,
attorney who does estate planning. Thank you, sorry.
didn't refer him instead. I just referred him to Crystal Bowman Carter to work more in tandem.
All right. And you said you haven't done that very many times, correct?
Right.
But there would be reasons to refer someone to an estate planner, fair? Just would there be reasons, yes or no, and then I'll follow up.
At the end of every divorce case, I refer every client I give every client a very long, again, to-do list and a closing letter. And at the end of that closing letter, I refer everyone or I recommend that everyone see an estate planning attorney to revise their estate planning documents now that they are no longer married.
Okay. In this case, however, that happened earlier in the process than normal.
Yes.
All right. And just let me ask you a hypothetical.
Sure.
So sometimes people have concerns about their children. I mean, it's a fair reason that people don't get divorced when they have small children because they don't want to break up the family. Fair?
Yes.
All right. And if an individual has concerns about providing, well, let me rephrase that. So hypothetically, someone may have concerns about how their children will be provided for after a divorce. Fair?
Provided for
Financially.
psychologically or financially?
Well, both, but I'm talking about financially.
Yes.
All right. So one reason someone may go to an estate planner could be to ensure that things were properly set up to provide for their family, whether they get divorced or not. Fair?
Are you talking about this early on in a potential divorce proceeding or just generally?
I'm asking hypothetically, well, generally first.
Yeah, people generally go establish an estate plan to make sure that if they have children, their children are taken care of, or that if they have assets, their assets are allocated the way they want upon their death.
Okay. And even though you said it's unusual, it's certainly possible that as someone is going through talking about divorce, they discover that they want to look at this now. Prior to divorce, they want to set this up. Part one of my question, is that possible?
I have never seen that, but I assume anything is possible.
Sure. And it's possible that someone may decide, instead of a divorce, I need to set up a way to make sure my family's taken care of. That maybe that's the more appropriate thing for me to do at this stage. That's possible.
I think you're probably comparing apples to oranges. In my experience, when someone is ready to move forward with a divorce, or when a divorce has been kind of forced upon them from their other spouse, it is because I explain it to clients as two pieces of wet noodle and we drop them on a plate, and one is the emotional divorce and one is the legal divorce. And my job is to straighten those out and keep them as separated as I can, because at touch points, when the legal divorce touches the emotional side is in chaos. And when the emotional side touches the legal side is in chaos. And so when you're going through a divorce, that in and of itself is an apple, where people are worried about what their kids' lives will look like tomorrow.
Understood.
Or next month. When you are doing estate planning, it is, what will my kids' lives look like if I am not here, or me and my spouse are not here? Like, is grandma going to take them? Is my sister going to take them? And so they don't often overlap, because people in divorce don't often, in my experience, they don't even really think about their estate plan. It doesn't come up in our cases, except for a very small handful of
Okay.
cases.
I understand it's a very small handful, but let me just try and ask once more.
Sure.
It's possible that while going through what a divorce is going to entail, someone can change their mind, correct?
Decide not to get a
And
divorce?
decide not to get a
course.
divorce, correct? And then it is possible that they want to go set up an estate plan, correct? Miss, that can happen.
I'm sure it can. I've never seen it happen, but I'm sure it can.
Okay. You don't, okay, I'll strike that. All right, but that's what happened here. Mr. Richins decided to see an estate planning, a lawyer who specialized in estate plans, correct?
What happened was, I advised him to seek an estate planning and attorney to help him with what I perceived as his concerns at that time with regard to his finances and his children.
Okay, thank you. I have nothing further at this time. Thank you.
Ms. Sherman,
No other questions, Judge.
may we release this witness?
Yes.
Ms. Lewis, may we release this witness?
Yes, Your Honor.
You're free to go.
Thank you.
Nice to see you.
Thank you.
Might take that cup with you.
Of course.
And your phone. Leave the binder there. Oh, is that your binder?
No,
You can leave it there. Okay.
Thank you. Take care, Ms. Miller. Counsel, any objection to breaking for lunch?
Whatever the court wishes.
Ms. Lewis?
No, Your Honor.
Okay. Folks, please rise for the jury. During the break, ladies and gentlemen, same instructions. Don't talk about the case. Don't read, watch, or listen to anything about the case. Do not do any research on your devices about the case. Please enjoy your lunch. We'll come back at 10:01. Thank you very much. Folks, have a seat. Thank you. Mr. Blood or Ms. Sherbanek, anything on the record before the lunch break?
No, Your Honor.
Ms. Lewis, Ms. Nestor, Mr. Ross?
No, Your Honor.
Okay. We'll be in recess until 12:50. Thank you. Council, we're back on the record. Ms. Shervanack, Mr. Bloodworth, anything before we invite the jury back in?
No, Your Honor, other than I'd like to clean up this.
Okay. Blame Mr. Burmester. All right. Ms. Lewis, Ms. Nestor, anything on the record before we proceed?
No, Your Honor.
Okay. Give me a preview. Who's the next witness?
Crystal Bowman Carter.
Okay. Will you get the jury ready to go and bring them in? Thank you. Please have a seat. All right, please have a seat. Ms. Shervanack, the state's next witness.
Crystal Bowman Carter, please.
Ms. Bowman Carter, if you'd step in front of Brittany, we'll get you sworn in.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Good afternoon.
Good afternoon.
If you could state your name and spell your last name, please.
My name is Crystal Bowman Carter. My last name is spelled BOWMAN-CARTER.
What do you do for work?
I'm an attorney.
What kind of attorney are you?
I focus on estate planning and a little bit of business work.
How long have you been doing estate planning?
I have been licensed since 1996 to practice law, but I've been doing estate planning almost exclusively since 2012.
And do you do that practice here locally?
Yes, I have an office in Park City.
Approximately how many estate plans have you drafted in your practice?
1,400, 1,500.
Did you know Eric Richins?
Yes,
How did you know him?
I did some work for him.
What kind of work did you do for him?
I did 2 projects for him. First, I did a buy-sell agreement for him and his partner for their business, C&E Stonemasonry. And then I did his estate planning.
Did you meet with him in person?
Yes,
How many times?
at least 4.
Did you know Kouri Richins?
I know of her. I've talked to her on the phone once the day that Eric died.
I want to talk about the first legal project that you did for Eric Richins. You mentioned that was related to his business, C&E Stonemasonry. Is that right?
Correct.
When did you complete this agreement, or when did you work on this project for him?
I was first contacted in June of 2018 by his financial advisor. We got the ball rolling. I gathered information, and then we ended up signing it almost a year later, June 25th, 2019.
Okay. In general, explain to the jury, what is a buy-sell agreement?
A buy-sell agreement is a contract between owners of a company that sets out the terms in advance. What will happen when there is a transfer of a business interest, whether it's by sale or because of an owner's disability or their death.
Are buy-sell agreements, in your experience, are they common?
Yes.
If we could show the witness exhibit 4-2, please.
Apologize. We'll fix that. Scott, if you unplug for me. You should be able to see this.
I can see it.
Do you recognize this document?
Yes,
And what is it?
it's the C&E Stonemasonry LLC buy-sell agreement that I prepared.
I'm going to move to admit 4-2.
Ms. Lewis, Mr. Ramos. Oh, Ms. Nestor.
No objection, Your Honor.
Okay, states 4-2 is admitted.
If we could publish this and move to Article 3, please. What's contained in Article 3 of this agreement?
Article 3 provides what happens if one of the partners or owners of the company were to die.
And essentially, what does it say in non-lawyer speak?
Well, the mandatory cross-purchase agreement provides that if one of the partners dies, either Eric or Kouri, then the decedent, the person who has died, their estate has to purchase the business interest from the surviving partner using life insurance.
And is that the life insurance was what was used in this buy-sell agreement?
Yeah, so this buy-sell agreement used 4 different $1 million life insurance policies. Each of Kouri and Eric had 2 $1 million policies on the life of the other, and if one of them were to die, they had to use that money to purchase the interest in C&E Stonemasonry from the estate, so that the survivor could continue to control the company and run the company.
Is that a pretty common
Yes.
thing in buy-sell agreements?
Excuse me.
That's
Yes, it
great.
is.
I want to move now to talk about the second project that you did for Eric Richins. You mentioned that was an estate planning
Yes.
project. Was that, did that take place in October of 2020?
Yes, he came to see me. He called my office on October 5th and came to see me on October 13th, 2020.
And so what was the purpose of that meeting?
It was to update his estate plan and revoke a prior power of attorney that had been abused.
When we're talking about an estate plan, what are the main documents that come out of an estate plan?
So the basic estate plan that everyone needs is a will, a durable power of attorney, and a healthcare directive. And sometimes, most of the time in my practice, you also need a trust to avoid probate and to protect the beneficiaries of your estate plan from themselves or from others.
Okay. In preparation for that meeting with Eric Richins, did he fill out some paperwork before and during that appointment?
Yes, I have all of my clients fill out an intake worksheet, gather information about their priorities and their assets. He partially filled it out, brought it in with him to our meeting, and then we filled out the rest together as we discussed what needed to be done.
And these intake worksheets, how is that something that your firm uses with every client, or how does that work?
Yeah, either my office manager or my receptionist sends it out to everyone. It's something I can't really function without.
Okay. If we could show the witness 4-9, please. And go ahead and scroll through it so she can see the whole thing. Do you recognize this?
Yes,
And what is this?
that's my estate planning worksheet filled out by partially by Eric and partially by me.
Okay, I'm going to move to admit 4-9.
No objection.
4-9 is admitted.
Now, if you could take that binder in front of you and turn to tab 9. Is that the same exhibit that we're looking at in 4-9?
No.
Okay. Which one is that?
You're having me look at the healthcare directive.
Oh, I see. We'll come back to that one. I had it labeled wrong. Before creating Eric Richins' estate plan, did you review a premarital agreement?
I reviewed it the day before he signed his estate plan.
Okay. If we could, 4-1 is the premarital agreement. That's already been admitted. If we could publish that, please, and go to section 1. And paragraph 5. So this is the document, the premarital agreement that you reviewed. What
Yes.
does paragraph 1, section 5, again, the non-lawyer version, what does this say?
So what it says is that C&E Stonemasonry would remain Eric's separate property to dispose of as he wished during his life after his marriage to Kouri Richins.
And if we could go to section 2, please. What does this section of the premarital agreement deal with?
Again, it deals with Eric's separate property, that C&E Stonemasonry will remain his sole and separate property, even if they commingle marital funds, except that if he were to die, then his interest in the company would pass to his wife, which is Kouri in this document.
Okay. And if we could go to section 3, please. And how about this section? What does this,
So that section addresses primarily Kouri's rights in C&E property that she might have under the law at Eric's death. Can I elaborate on
Sure.
that? Okay. So if you don't have a premarital agreement, then you have rights in your spouse's estate. And when you're a nuclear family with no children from a prior marriage as they were, that means that if your spouse dies, you are entitled to at least 1/3 of the augmented estate. In other words, everything that passes to anyone as a result of your spouse's death. And this paragraph, the section 3, paragraph 1, says that Kouri is giving up her right to that 1/3 as it concerns C&E masonry, stonemasonry.
so I want to turn your attention now to that actual meeting that you had with Eric Richins in October of 2020. What was he there to accomplish? Why was he in your office?
He was referred to me, I'm not sure if it was from Christina Miller or Brian Freckleton, referred back to me. I had worked with him again to update his estate planning based on some recent financial malfeasance and some current concerns that he had for his sons, that if something were to happen to him, they wouldn't receive or be cared for financially with his assets.
When meeting with Eric Richins, was there something unique to you or something that you did for the first time in preparing his estate plan?
Yeah, there were a few things.
What were those?
So, one, he didn't want us to communicate with him by email. That happened a little bit later, but because he was worried that Kouri would be reading his emails. 2, he wanted to leave everything to his kids if possible. And at the beginning of the representation, I hadn't seen the premarital agreement. He wasn't sure if it existed, but eventually communicating through his sister as he instructed, we received the premarital agreement and saw that it unfortunately did not address all of the property. It only addressed C&E stonemasonry. So for that reason, for the first time ever in my career, I had to draft around that augmented share. So we provided at a minimum that there would be a share created for Kouri consisting of 1/3, the amount she would be entitled to. And the rest passed directly to his kids. That also applied to tangible personal property. He said that all his tangible personal property, things you can touch and feel, like your furniture, your jewelry, your collections, would pass directly to his sons, who were all very young at the time. And that's unusual. It usually passes directly to the spouse. I think there was one other thing, but I'll come to it.
If it comes to you, let me know.
Mhm.
So I want to turn your attention now to those estate planning documents that you referenced that you prepare when doing estate plans for most people. And for Eric Richins, did you prepare a living will?
A living will, a healthcare directive?
Yes.
Yes.
And did you also prepare a trust?
Yes.
Okay. I want you to take a look at Exhibit 4-11. We'll put it up on the screen for you. And if you could scroll through it, Scott. Do you recognize this?
Yes, that's the will I prepared for Eric Richins.
And then if we could show the witness 4-12. Do you recognize 4-12?
Yes, that's the trust I prepared for Eric Richins.
Now, in the book you have in front of you, I'm going to ask you to turn to tab K or to tab 6. Is that the will that we just saw in the same exhibit?
Yes.
And there's a signature as a part of that document. Is that correct?
Yes.
And who is that document signed by?
The document was signed by Eric Richins on page 8, and his initials appear on every single page of the document.
And you notarized that document, right?
I witnessed and notarized the document.
If you could turn to tab 10 in that binder. Is that the trust document that we just saw?
Yes, it is.
And is that document also signed?
Yes, it is signed. It's signed by Eric Richins, and I notarized it.
Okay, and that means you saw him sign it in front of you, right?
Yes, you have to, if you're a notary, you're required to be there in person to witness somebody signing something before you can attest to their signature.
And then also on tab 9, you told us that was the healthcare directive, is that right?
Yes.
And is that document signed?
Yes, it is.
And similarly, did you see Eric Richins sign that?
Yes, I did.
Okay. I'm going to move to admit 4-11 and 4-12.
Objection.
4-11 and 4-12 are admitted.
If we could put up 4-11, please, and publish to the jury.
4-11's up.
And so this is the will you described that you prepared for Eric Richins. Is that correct?
Correct.
I want to go to section 7.03, please. What does this section provide for?
That's the section where Eric expressed his intentions for the disposition of his remains. He wanted to be buried upon his death.
Now, talk generally about this document and what kind of legal implications, this document has.
So in the case of a trust-based estate plan, which is what we prepared for Eric, the will is not usually as important as the trust. All of his directions for what he wanted to happen to his assets and the protections he wanted to put in place for his loved ones were contained in the trust. You still have to have a will. It's called a pour-over will. It says that if I leave anything out of my trust, if I forget to make a beneficiary designation when I die, give it to my trust to be controlled by the terms of my trust. And then I always include either burial, cremation instructions if somebody has a preference. Sometimes people don't have a preference, then I don't say anything. Anything that's governed by a will has to go through a process called probate. That's a court supervised process of administering an estate, the non-trust assets. So when you draft a trust-based estate plan, or when you execute a trust-based estate plan, the idea is you're avoiding probate. You don't need to use the will. It never has to go through probate. The will is just a backup document.
So now if we could put up 4-12, please, for the witness, and we can publish this as well. So talk about, in general, how a trust works.
Okay, so a trust is a contract between, and I'm going to use Eric specifically because this one was prepared for him. It's a contract between the party who drafts it, the party who's going to benefit from it, and the party who's going to administer it. So initially, a trust is a contract between you, me, myself, and I. Eric was the grantor. He created the rules for the trust. Eric was the trustee. That means he was the manager of the trust, of all the assets that were contained in the trust and had to follow the rules that he set. And then Eric initially was the beneficiary until such time as he became, until he died. He was the trustee until such time he became permanently incapacitated or died. And then somebody else would manage those trust assets. It's like a box that you have rules for. You put the assets in, and those rules control all of the assets in the box.
So you mentioned that a trust, the trustee was Eric while he was alive.
Yes.
And then he chose someone else to be a trustee in the event of his death. Is that correct?
He did. That would be at Article 3.
Okay. Who did Eric choose as his trustee?
He chose his sister. Well, he chose a couple of successors. His sister, Katie Richins Benson. And then I want to see who he chose as this. And then I'm looking at the will still.
That's okay. You don't have to look at it. If you don't remember, that's okay.
No, it was Katie that he chose as his first successor trustee, and I believe it was Clint as the second.
What is a trustee?
The trustee is the person who has legal title to the assets in the trust and is charged with managing those assets for the benefit of the beneficiaries of the trust in the way that the trust says.
In your experience, was it unusual for someone who was married to not choose their spouse as a trustee?
Yes.
What effect did the trust have on Eric Richins' property?
While he was alive, he could still do anything he wanted with the trust assets because it was a revocable trust. But the trust owned his property in that little box. And the effect was that when he died, it became irrevocable, and those assets had to be administered according to the terms of the trust that he set.
Scott, if we could go to Article 8.01 of the trust.
Excuse me.
Describe for the jury, in layman's terms, what this section of the trust means as it pertains to Kouri Richins.
Okay. Might be a little wordy here. So on
Your best.
on Eric's death, this trust became irrevocable and sub-trusts were created. A trust for Kouri called the Q-tip trust that you see here at Article 8. And then the next trust is the Descendants Trust that was for the benefit of the kids. Because it was a Q-tip trust, the law requires that all of the income generated by the assets held in that share must be distributed to Kouri during her lifetime.
So did the trust provide for Kouri Richins' household expenses?
And not specifically, but the guidelines for distribution also provide that she's entitled to also access the principal through the trustee for her health, education, maintenance, and support. So yes, she was provided for, just not household expenses specifically.
And you mentioned that a trust is like a box that someone can put their assets into. What were some of the assets or the assets that went into Eric Richins' trust?
So the easiest thing we did was he signed an assignment of tangible personal property. So things that don't get titled anywhere, like your furniture, your jewelry, those collections. By signing that document, that transferred those things to the trust. I prepared a deed for him for the house that he owned in his name, and we transferred that asset to his trust. I think the house was on Willow Court. And then I prepared an assignment of interest in C&E Masonry that he signed later on in February. After the trust was built, then we could put the things in it. And he signed that in February of 2021, put that in the trust. And also another LLC interest.
Scott, if we could go back to just the first page of 4-12,
Eric already
please.
knew what was going to happen. He had foreshadowing.
Even the title page for, yeah. So that document has a date on it. What's the significance of that date?
That's the date that Eric signed the trust, and for titling purposes, we include the date in the name of the trust.
And so for all intents and purposes, that's the effective date. That's when it becomes legally in effect.
That's when it becomes legally binding, yes.
If we could show the witness 4-14, please.
Scott.
And if you could scroll through it so the witness can see the document. Do you recognize this document?
I do.
Did you prepare it as part of Eric Richins' estate plan?
Yes, it's the power of attorney that I prepared for him.
I'll move to admit 4-14.
No objection.
4-14 is admitted.
If you could explain, you mentioned that this is a durable power of attorney. What is a power of attorney?
It's a document that nominates an agent, somebody that you choose to manage your property if you become incapacitated, or sometimes immediately.
And what effect did Eric Richins' power of attorney have on his estate plan, or who did he choose as his power of attorney?
I'm sure he chose Katie Richins Benson.
Okay, if we could show the witness, I don't want you to look at anything just yet. If we could show the witness 4-13, please. Do you recognize this document?
Yes.
What is it?
I'm scrolling through it. It's a draft revocation of a prior durable power of attorney.
Is this also a document that you prepared for Eric Richins?
Yes.
I'm going to move to admit 4-13.
No objection.
4-13 is admitted.
If we could publish 4-13 to the jury, please. So this was a document that you drafted as part of Eric Richins' estate plan, is that right?
Yes, I drafted it, and then you can see that there's the prior durable power of attorney is attached as an exhibit. I didn't draft the prior power of attorney.
Certainly. Was this document ever recorded?
This version of the revocation of durable power of attorney was never signed or recorded.
Do you know why?
Eric was concerned about the repercussions he would face if he told Kouri.
Object to hearsay, Your Honor.
That was my impression.
Pause. Please approach. My apologies.
Very interesting to observe Kouri in court and how defendants carry themselves. Crystal Bowman Carter, estate planning attorney. Very interesting to see the mirror in the back of the courtroom. I didn't notice that before.
The jury, I appreciate your patience. You cannot consider what Eric Richins said to Ms. Bowman Carter.
And so I'm not sure if your answer was heard by the jury. I won't ask you why, but was this document ever recorded?
No, this document was never recorded.
Okay. Now, you mentioned earlier that you were communicating with Eric Richins' brother-in-law, I believe.
I had communications with Eric Richins' brother-in-law, yes.
And you were instructed to only communicate with the brother-in-law, is that right?
I was instructed to communicate with his sister, and then I was given I believe it was a shared email account.
Okay.
And they both responded there.
Was that unusual in your practice?
It was the first time anyone had asked me to do that, so yes.
Okay. I now want to turn your attention to the week that Eric Richins died. Did there come a time when you learned that Eric Richins had died?
Yes, I learned that day that he had died, March 4th, 2022.
And is that when you became aware of it, or was that a day later?
I believe I learned the day that it happened.
And how did you learn about Eric Richins' death?
Clint Benson called me and told me that he had died.
And did you also receive a call from a sheriff's deputy that day?
Yet later that day, I received a phone call from somebody who identified themselves as the sheriff deputy and who asked me to talk to Kouri.
And did you talk to Kouri on the phone that day?
Yes.
What did you tell her?
Apparently, she was upset about the house, and I was asked to explain that there was an estate plan in place and that the house belonged to the trust, and that's what I told her.
When you were explaining to Kouri Richins that the house belonged in the trust, how did she react?
Oh, not positively. She was livid. She was upset, and she said, "What is wrong with you people?" and handed the phone back to the officer, I believe.
When having this conversation with Kouri Richins, was it your impression that she was unaware of the estate plan?
Object to speculation, Your Honor.
I'll lay a little foundation.
What could you tell from your conversation with Kouri Richins about her knowledge regarding what would happen with the house?
She told me that the house she told me the house belonged to her. She thought the house was hers, and obviously, if she thought that, then she was unaware of the estate plan and that the trust owned the house.
When were you contacted by an attorney representing Kouri Richins?
Yeah, a bankruptcy attorney reached out to me.
Objection, Your Honor. Can we approach?
Sure.
So you mentioned that you received an email from an attorney representing Kouri Richins. Is that right?
I received an email on March 8th from an attorney that said he represented Kouri Richins.
Okay. What, and so, sorry, I missed the date that you said. He contacted you on March 8th, is
March
that right?
8th, 2022.
What was the general nature of that email?
Just to tell me that he represented her and to ask that we give her time to grieve, don't act too quickly, so that she could attend to services, and I believe that was it.
And so he was contacting you in reference to the estate plan, is that right?
Possibly. I'd have to look at the email, but I don't even know if he referenced the estate plan.
He was talking about the house that was in the estate plan, is that right?
Yes.
Did you, after that email exchange on March 8th, did you provide any documents to Mr. Nate?
Yeah, it was Attorney Nate, and I did provide him with a full copy of the estate plan. I pointed out several things, including that the will called for burial and asked.
Yeah, go ahead. You can finish.
And asked and because I had become aware that Kouri was seeking to have his body cremated, so I wanted to make sure.
Hearsay and non-responsive.
Well, taking him in reverse order, overruled, and it's unclear, so I'll sustain it, lay some more foundation.
Sure. So one of the documents that you provided to Mr. Nate was the will. Is that correct?
That's correct.
And one of the reasons you provided him the will was so that he was aware of Eric Richins' wishes as it concerned his burial.
Yes.
Did you open probate on Eric Richins' estate?
Yes.
When did that happen?
March 14th
Of 2022?
Only 10 days after Eric's death.
In your experience, is that, first, I'll ask two questions about opening probate. Was that a typical time frame for those events to happen?
No, that wasn't a typical time frame.
What do you mean by that?
Well, a couple of reasons. Usually people need to get through the services and grieve a little bit. If the property is secure, there's no reason to open probate right away. But in this case, Eric had a fully funded trust. I never would have opened probate if we were just administering the trust. That's the whole reason you have a trust, is to avoid having to go to court, make everything public.
And so when you're saying the time frame was not typical, it was quicker than usual. Is that fair?
Yes, it was much quicker than usual. And with a trust, I just wouldn't have opened probate. If at all, I would have opened probate a year after the death, after creditors' claims had been cut off.
And so you opened probate quickly because there was some urgency, in your view?
Yes. Eric had, can I explain why?
Please lay some foundation for how she knows whatever she's about to say.
Well, sure. Did you, can we approach? I don't want.
Ms. Shervnak, please proceed.
Without telling us any specific statements or what anybody said, Why did you open probate so quickly?
I needed to get the nominated personal representative in place so that she, Katie Richins Benson, would have the ability to manage the probate estate and and make sure that Eric's wishes, as expressed in his will, were followed.
Thank you. And I neglected to check. Have I admitted Exhibit 4-14? I know I talked about it with this witness. Did we?
Sorry, wrong one. It wasn't me, Your Honor, without
Okay,
objection.
I just didn't have a note there, so I wanted to make sure I admitted it.
Ms. Nestor is correct. It's admitted without objection.
Those are all my questions. Thank you.
Ms. Nestor, please.
Thank you, Your Honor.
Good afternoon, Ms. Bowman Carter.
Good afternoon.
My name is Kathy Nestor. I'm one of the attorneys representing Kouri Richins today. All right, so I want to talk with you about the revocation document that you talked about with Ms. Shermanak. Could we please bring up 4-13? It's been admitted, Your Honor.
One moment. You can see that, Ms. Bowman?
I can see it.
Okay, go ahead,
All right.
Ms. Nestor.
And can we scroll down to the beginning of, or actually the very bottom of it, the date of the original one that they were contemplating revoking? And just to refresh, you mentioned on direct, this was actually never done. You actually never did revoke this power of attorney, correct?
Incorrect.
Okay, I'm sorry, I may have misunderstood you. I thought you said that you all ended up not revoking it.
No, I said we'd sign this document.
You didn't sign it.
Mhm.
So I know what you're getting at. So in your durable power of attorney, you mentioned revoking all previous powers of attorney, correct?
That's not what I was getting at, but that's correct.
Okay. But this particular document never got signed or filed or anything.
No, another revocation got signed apart from the durable power of attorney that he signed.
Okay. And the date on this document that you all were contemplating revoking, but didn't ever sign this document, was May the 8th of 2013. Is that right?
That's what this document says.
So this is the power of attorney that all the parties were contemplating, saying you can't use this anymore, right? From now on.
This power of attorney was revoked, yes.
I'm trying to not use lawyer words. I'm trying to use like normal words, just so to make sure we're clear. So revoke just means we can't use it anymore, right?
Right. It's taken back. It's null and void.
Perfect. Thank you. That's what I was getting at. So to your understanding, this power of attorney there'd been no prior revocation filed on this power of attorney. In other words, it had been in place since May of 2013.
Right, but circumstances changed and he wanted to revoke it.
Sure. Anybody can revoke a power of attorney anytime they want, right?
Correct.
But he hadn't done that up until now, till he saw you in 2020.
That is my understanding. He may have gone to someone else, but this is the first time I learned of it.
Okay, thank you. You can take that down. Do you remember being interviewed by law enforcement within about a year or so after Eric passed?
Yes.
Okay. And when you were interviewed by law enforcement, do you recall telling them that it stuck out in your mind how kind Eric was about Kouri using that power of attorney in a way that he didn't like, right? Do you remember that?
Objection, Your Honor. Calls for hearsay.
That's her own statement, Your Honor.
Which is why it's a problem that it's coming in through you.
Well, I'll lay a little more foundation.
Sustain.
Was it your understanding that the goal of revoking this power of attorney that had existed before was that Kouri couldn't be trusted to utilize it well.
Yes.
And why couldn't she be trusted to utilize it well?
Because she had she had misused it to take $250,000 out in his name, and he did not like that.
Totally fair. And isn't it also true that it was your understanding that Kouri's business acumen or business skills were less than fantastic because she was young and inexperienced?
I have no personal knowledge about Kouri's business acumen and skills.
Did you make that statement to in your prior interview to the police?
I repeated what Eric told me about her business acumen and skills.
Okay, and what was your understanding of that?
I had no understanding of her business acumen and skills.
But what'd you tell the police?
I told the police what Eric told me.
Which was what?
That she was misusing the power of attorney, that I wanted to include stronger language in his estate plan, more protective. I was surprised that he was willing to. He said that she's the mother of my children. I know that she made mistakes. She needs some more experience. For now, I'm going to do what I'm doing.
Great, thank you. Was there also, when you decided to add the house to the trust, did you do any investigation into whether Mrs. Richins had been contributing to the mortgage throughout the marriage?
I did not. Wasn't relevant.
Okay. When you said that all of Mr. Richins' personal property was poured into the trust, did you do any investigation into whose funds purchased all that personal property?
It wouldn't matter if it was gifts, but no, I didn't.
So, for example, the furniture in the living room, do you know whether Kouri purchased it with her money or Eric purchased it with his money or it was joint money? Do you even know?
No, how could I know?
Okay. And you made no effort to find out?
The assignment that Eric signed transferred his personal property.
Right.
If
So you took his word for what was his personal property as opposed to what was hers?
I didn't have to take his word. He was only transferring what was his personal property.
Okay. And did he give you an inventory of what that personal property was?
No.
Okay, so you didn't know.
Well, there's a worksheet and he listed some things like his guns, but he didn't prepare a very specific inventory. I just prepared an assignment that he signed transferring all of his personal property to his trust, as is customary.
So that would ultimately be decided probably by the trustee, whether she was trying to divvy up the proceedings as required under the trust, whether that couch was bought by Kouri or that couch was bought by Eric.
That's likely.
And you didn't give any guidance to that in the trust, the document itself.
What are you asking?
Was it listed in the trust, each and every item that was considered Eric's personal property?
No, it was just all of my household furnishings in effect.
Okay. You said all the household furnishings were his personal property?
No, I said all of my household furnishings and effects, meaning all of Eric's household furnishings and effects.
Gotcha. Okay. You also, in the trust documents that you drafted, it's pretty common that you do with something called a statement of intent, right?
No, it's not common at all.
So it was unusual that you did that.
Yes.
Katie, can you pull up 412, page 1-2, section 103? This is in, Your Honor. If we could publish.
Okay. There you go.
And can you blow up the statement of my intent? So this is the part you said is unusual for you to do.
I mean, it's not unusual to, trusts will have them, but for me, I typically don't include one unless there's a reason.
So did you have a reason for including this?
Yes.
Okay. And I assume it's something the client wanted?
Yes.
Okay. And the language in here states that the intent of the trust is to provide for both Mrs. Richins and the children throughout their lifetime, right?
Right. We revised that the day of signing.
Great. You can take that down. Did there come a time, you mentioned that it was your understanding that Mr. Richins did not want you to communicate with him directly, right?
By email directly.
Right. And is that because he and his wife shared an email account?
I don't know. It was Richins, I think. I don't think they shared an email account. I don't know.
Okay. So you just don't know.
It was not because they shared an email. What he told me was not because they shared an email account. It was because she snooped in his email.
Okay.
That's what
So
he
she had
told me.
access to his email at least.
I don't know. That's what he told me.
Okay. And were you aware at that time that he was consulting a divorce attorney?
Yes.
So when you previously said it's very unusual to not put your spouse as a trustee, if the individual was considering divorce, that wouldn't be unusual to put someone other than your spouse, would it?
No, that wouldn't be unusual.
Okay. And was there a time where you accidentally did notify Kouri of something?
Yes.
Explain that, please.
Kouri Richins, Kay Richins, and Katie Richins Benson. Very similar names.
Sure.
After I spoke to Kouri on the phone, I sent an email to Katie, I thought, which actually got sent to Kouri.
Okay. And in that email, do you remember the date of that?
It was probably March 4th, the same day that I talked to, it may have been March 5th, but I think it was March 4th, 2022. Right. The same day I talked to Kouri.
And just talking about that conversation you had with Kouri, so this is less than 48 hours after her husband has died, right? Give or take.
Yes.
And your purpose of your conversation was at Katie Benson Richins' request?
No, it was the police's request.
Okay. And what you told her before she got very,
Interesting.
very upset was the house that you live in is not yours.
I told her that she did not have title to the house.
Okay. So basically, you're telling a new widow that she's also about to be homeless?
No, not at all. That's ridiculous.
That's
Over.
just legal. Come on. Wow.
Did you tell her there was any other homes provided for her by Eric waiting on her somewhere?
No, but I told her that he had that she would not be kicked out of the house, that she could continue to live there, and that he had provided for her in his estate plan.
Okay. And if I understand your previous testimony correctly, you never actually asked her, what did you know about all this before he passed, did you?
No.
So you don't know whether Kouri Richins knew there was a trust before he died?
It was apparent that she didn't.
I'm sorry. Do you have any personal knowledge as to whether Kouri Richins knew before his
Yes or
death
no?
that there was a trust in place?
No, I have no personal knowledge of that.
Okay. I want to talk about the intake form that Ms. Shervinack went over with you. If we could please pull up 4-9. It's also been admitted, Your Honor. And if we could scroll forward till we get to the page where he lists his assets. Keep going. Keep going. Keep going. Keep going. There. Your Honor, can we blow this up just a little bit, that top half, so we can see it? All right, so this is the section where you ask the client to list, I guess, what they're worth, right?
Yeah, that is a summary of the assets listed on previous pages.
Okay.
$7,670,000.
Mr. Richins, it looks like, wasn't sure about stocks and bonds, life insurance, and retirement, and directed you to ask Freckleton, right?
That's pretty common. Clients don't want to fill everything out, and he knew Brian Freckleton had worked with me before on the buy-sell agreement. He said, talk to him about that stuff.
But he does say that they had $100,000 in bank and savings accounts
Yes.
at the time,
That's what this document says.
and $65,000 in vehicles at the time.
Well, you said they. He says he.
Okay. 65,000 in vehicles,
That's what this document says.
and 30,000 in furniture and personal items,
That's what this document says.
and $1 million in real property.
Yes, that's what this document says.
And it looks like he's valuing his business, at least his share of the business, at about $3 million.
That's what this document says.
All right. And that he had some anticipated inheritance, not a ton, but some. Right?
That's what this document says.
So his best estimate of his net worth was about $4.6 million if you don't include stocks and bonds, life insurance, and retirement plans.
That's what this document says.
So as long as he's alive, I believe you said that he could do whatever he wanted with any of the money that was assigned into the trust, right?
Yes.
Because it's revocable.
Yes.
So as long as he's alive, he can share any of this money that he wants with his wife.
He can make gifts to whoever he wants.
And he can share 100%, 0.5%, whatever he wants as far as his monthly income, right? With his wife.
I'm not sure what.
So nothing about a revocable trust prohibits him from, if he's making $33,000 a month, giving his wife half of that or more.
He can do whatever he wants with his property.
And if he lived to be 70, he could give her as much as he wanted until he's 70, right? No matter what the trust says.
Like I said, he can do whatever he wants with his property.
But the minute he dies, Katie Richins Benson decides how much money, if any, Kouri Richins gets, right?
Correct.
The successor trustee, who happens to be Katie Richins Benson, has to follow the rules of the trust set by the grantor, who is Eric. So no, Katie can't do whatever she wants with the money. She has to follow the rules of the trust.
Totally fair, and you're
that
right.
Were set by Eric Richins.
But she's the one who will decide from the moment he dies forward whether, if, how much Kouri gets any of Eric's money.
Yes, that's what Eric wanted.
And if, hypothetically, Kouri Richins knew about the existence of the trust, she would know that as well.
I don't know what Kouri would know from reading the trust.
But that's what the trust says in plain black and white in the paper, right?
Can you repeat what you're saying the trust says?
Yep, that
For a moment. Go ahead, Ms. Sherman.
Your Honor, it calls for speculation. She does that. She can't answer as to what Kouri would know.
Sustained.
the trust, if someone had a copy of it, lays clearly out what we've just discussed, that as long as Eric's alive, he can do whatever he wants with his money. Once he dies, it's up to Katie.
Like I said already, it's not completely up to Katie. She's the trustee of the trust. She has legal title to those assets, and she has to follow the rules of the trust, which say she has to give Kouri a certain income, that Kouri can come to her and ask for distributions of principal for health, education, maintenance, and support. This trust was primarily to protect the boys.
Did you ever advise Katie in her role as trustee, since you drafted the trust papers? Did you ever give her any explanation about her duties or talk to her about what she could and couldn't do?
That's attorney-client privilege.
She's your client?
She was my client after Eric's death for a period of time.
As of when was she your client?
As of Eric's death?
She's still your client?
No.
How much have you been paid by Katie Richins Benson?
I waived my fees.
You waived your fees. So you're her lawyer for free?
I'm not her lawyer anymore.
Okay. How long were you her lawyer?
I was her lawyer through, I think I formally withdrew in June. She needed a firm that had more capacity than I had with just me.
When you opened the probate, were you then responsible for any pleadings that came in and out of the probate matter? Would you have gotten copies of them?
I opened probate. I drafted the probate pleadings.
Right. So if, for example, Kouri had asked Katie after Eric's death, can you please pay the mortgage for the next year out of the trust? That request would have gone through the probate, right?
No.
Okay, so how would it have gone?
Katie was the trustee of the trust. That is not subject to probate.
Okay. So do you have any personal knowledge whether whether Kouri Richins ever asked Katie Richins for any distributions? Do you have any personal knowledge?
Pause for 1 second. Your objection, Ms. Sherman.
Calls for hearsay. Kouri's statements to Katie?
Yeah, only if it's, so would you exclude Kouri's statements, but re-ask your question?
Without saying anything Kouri ever said, which, by the way, it sounds like you didn't communicate with Kouri anyway, but were you aware in your role as the person assisting the trustee whether any request for any money ever came to that trust in the year after Eric died from Kouri Richins?
I need you to be more specific to make sure you're not seeking hearsay. Break it down.
In writing or legally or formal request to the trustee?
What in writing or legally?
Requests for distributions to Kouri, to her boys, anything from the trust?
I have no personal knowledge of that.
Okay. You also mentioned that you were talking to a lawyer that you knew to be a bankruptcy lawyer, right? When he called you about Kouri shortly after the death?
I was surprised at how quickly he got in touch with me and some of his claims about the way the property was titled. So I looked him up to see if he even knew anything about estate planning.
But you're certainly not telling this jury that he was representing Kouri in a bankruptcy, right?
No, I
Okay.
just was curious. So I looked him up to see that it made more sense when I found out he was a bankruptcy attorney.
But he wasn't calling you about a bankruptcy matter. He was calling you about, please give Kouri some time to grieve before anything goes on with the house.
He never called me. I mean, he called me later, but in the email, he asked, please don't move forward on the probate until she's had time to grieve.
Okay.
He
And you
didn't
gave-
mention a bankruptcy.
All right. I just want to make sure that the jury doesn't think there was a bankruptcy matter going on. There wasn't, to your knowledge, correct?
I have no idea.
Okay. And then you also said that you told this lawyer that Eric wished to be buried. Is that right?
That's what his will said, and I did say that in a subsequent email.
And in fact, Eric was buried, correct?
I believe so.
Right. Did you go to the funeral?
No, I didn't.
Are you still close with his sister?
No, I've never been close with his sister.
Okay, well, you were her lawyer.
That doesn't mean I'm close to her.
Oh.
It was a professional relationship.
Okay. How often did you talk to her
When
you were her lawyer?
as needed.
Daily, weekly, monthly?
I think it was daily at first.
Court's indulgence for just 1 minute, Your Honor.
Of course.
Thank you, ma'am. Your Honor, we send the witness back to the state.
Anything further, Ms. Sherman?
No, Your Honor.
May we release Ms. Bowman Carter?
Yes, Your Honor.
You're free to go. Take care.
Thank you, ma'am.
Counsel.
Your Honor, the state can call a witness now. That direct will probably be an hour.
Why don't we take a restroom break now so we don't break up direct? Please rise for the jury. Folks, have a seat, please. Just checking, the next witness is,
Robert Grossman.
okay. And then anything on the record before we take a break from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Okay, why don't we come back at 2:10, please? Court's in recess.
That lawyer definitely seemed a little bit defensive, very interesting. I wonder why she's no longer Katie's lawyer. Maybe she stepped away. Sometimes lawyers do that if they don't want to deal with any more of the court actions. They'll testify to what they need to and then move on to another case. All right. Sorry again. I am sick, so I'm not visibly online, but making a little bit of commentary. but also adding more content for you all to go through in the future when I have a lot of subscribers. So, anyway, I'll be back when we're back.
231-500-139. The jury is lining up. Mr. Bloodworth, anything before we invite them in?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. We're ready for them when they are. Will you bump Ms. Osterloh for me? All right, jury. Folks, please have a seat as you come in. Please have a seat. Mr. Bloodworth, the state's next witness, please.
Your Honor, the state calls Robert Josh Grossman.
Mr. Grossman, good afternoon. If you'd step in front of Brittany, we'll get you sworn in.
You please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Sir, do you swear to tell the whole truth under the pains and penalties of perjury, yes or no?
I won't lie. I'll tell as much as in this setting, I assume all the answers to questions not.
Stand right there for a moment, if you don't mind. Can I invite you folks to take a walk for a moment? Please rise for the jury. Just pause for a moment. Have a seat for me, if you don't mind. Mr. Grossman, do you understand the difference between what's true and what's not true?
I do.
Do you promise, under the pains and penalties of perjury, to tell the truth when you're asked questions?
Absolutely.
Anything further, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Would you bring the jury back?
Your Honor, an instruction that he's taken enough.
I'll make it clear. So that you're not surprised, I'll just ask you to confirm that you've sworn to tell the truth.
Yes, sir.
Okay. Folks, please have a seat as you come in. Please have a seat. Mr. Grossman, just to confirm, you have sworn an oath to tell the truth, correct?
Yes, sir.
Very good, sir. Mr. Bloodworth, please proceed.
Thank you, Your Honor. What, sir, is your name?
Robert Joshua Grossman.
Sir, do you know Kouri Richins?
I do.
How do you know her?
I've known her for, I don't know, a decade probably at this point. We met in South Carolina. She was flipping a house and I answered, and a help wanted ad.
Then did you come to know her in South Carolina through helping her flip homes?
I did.
Did there come a time you moved to Utah?
Yes.
When, sir, was that?
It was just as COVID was kicking off. So 2020, I believe, or early in the year.
And why did you move to Utah?
To work with her, help her flip houses.
And when you moved to Utah, where did you stay?
Initially, I stayed at a flip that she had acquired in Heber. I had my dog with me. We do live-in flips, me and the dog. Yeah.
Other than accommodations, did she pay you for your service?
We didn't have any contractual agreement. She took care of me. I lived for free. She gave me money whenever I needed it. I just, I liked her, so I'd work for free. Not that she didn't, pay me. She did from time to time in lump sums. And
did she also give you a truck?
yes, she bought me a truck. 2 of them. Bought me one, traded it in, got another one at one point. Didn't trade it in, gave it to her mother. Yeah.
Did, sir, there come a time when your relationship turned romantic?
Yes.
About when?
Same time, just before driving to Utah.
So right about the outset of COVID.
Right.
Scott, can I get Exhibit 3-1, please?
The witness has it.
Thank you, Your Honor. It's been admitted. Can we publish it? And Scott, can you zoom in on the top portion? Thank you. Mr. Grossman, do you recognize that document before you?
I know what it's alluding to. I know of it. Yes, sir.
And did you know about a trip planned to the secret St. Martin's Resort?
Yes.
So I'm going to take a look at the passenger name line. There's some initials there. RG with a birth date of 9 December 1982 and a gender of male. So are those your initials?
Yes.
Is that your birthday?
Yes.
Perhaps obviously.
Yes, definitely.
Thank you. Did you and Kouri Richins at some point plan to go on this trip?
Yeah, she. I think that was a birthday present. I remember seeing a text or something. She sent it to me. We didn't discuss it much, but it was there.
Thank you, Scott. During that time that you were romantically involved with Miss Richins, did you love her?
Yes.
During that time, did you feel that she loved you?
Yeah. I have a tendency of going head over heels, though, probably more than most. So, you know, I think she did.
Did you exchange text messages with Kouri Richins?
Yes.
From the time you moved to Utah, about how often?
Daily, unless she was mad at me or vice versa.
What topics on those messages did you discuss?
Same thing you would discuss with your best friend, plus house flipping stuff. Life.
Did you discuss her children?
Yes.
Sir, I'm going to show you now some text messages between you and Ms. Richins.
Okay.
They're the same ones I believe we've looked at before. I'm going to ask you if you've recognized them. If you can recognize them right away, that's fine. If you would like me to scroll down through them again, I'm happy to do that, okay?
Okay.
Scott, can I get exhibit 2-13 Delta, please? Can you just kind of scroll through the whole string without zooming in? Just, yeah.
Those are pretty small. If you need people to zoom
Yeah.
in, you can ask, sir.
Is that good enough for you to identify them, or do you want to zoom in and step through them?
I mean, if you could zoom in a hair, that wouldn't hurt.
Okay.
Was I supposed to be reading them at that clip?
No, I just,
Right there?
what I'm going to ask
Okay.
you, the
I got
question for you, sir, is do you recognize this as a text exchange that you had with Ms. Richins?
I got you. And I do for this one.
Okay. Then the state moves to admit 2-13D.
Could you just, Scott, could you just scroll down and let me take a look at everything that's in there real quick? Keep going. Okay. All right. Okay. All right. Okay. Okay. Is that it? Oh my gosh, never mind, okay.
Council, take the time you need.
Let me just pull it up real quick. I don't believe I have any objection to that one. I'm gonna say no objection.
States 2-13D is admitted.
Your Honor,
You'll let me know when you want to publish them.
moves to publish, yeah.
Understood.
And then, Scott, if we could just walk through them with the jury, please.
Very interesting. It's so revealing and so personal to have all of your texts uncovered. I'm not sure what they're doing here, actually, if they're just letting everybody read them and no. I don't know why this is all silent, but maybe Scott is setting these all up for the review.
Thank you, Scott. That text was from December the 18th, 2021. I meant to go in chronological order.
That was all one day.
Sir, we're going to go back in time to November the 29th, 2021. Scott, can I get 2-12 Delta? Can we scroll that through that for Mr. Grossman and council, please?
Yeah. Yes.
Sir, is that an accurate depiction of a text exchange between you and Kouri Richins on November the 29th, 2021?
Yes.
Your Honor, the state moves to admit 2-12 Delta.
No objection.
States 2-12D is admitted.
And Your Honor, publish it, please.
Yes, sir. Water. Yeah, no problem. Grab a glass and there's cold water in there for you.
Wow, it's a lot of emails to go through.
Thank you, Scott. Scott, can I get 2-18 Delta, please? Can you please scroll through it for Mr. Grossman and counsel?
Very long process.
Sir, is that an accurate depiction of a January 9th, 2022 text exchange between you and Kouri Richins?
I mean, I think so. I didn't necessarily recognize some of it. I saw the word dope sick in there. That doesn't, I don't know that that's, can you scroll back up to that one? That just doesn't seem like a topic of conversation of ours, or it doesn't seem like a word I recall.
Other than that word, does it appear to be an accurate depiction?
Oh, okay. Yeah. Yeah, it's a TV show. Yeah.
Your Honor, the state moves 2-18D into evidence
No objection.
States 2-18D is admitted.
and to publish, Your Honor.
There you go.
Thank you, Scott. Can I get 2-27 Delta, please? Please scroll through it for Mr. Grossman and counsel. Sir, is that an accurate depiction of a February the 14th, 2022 text exchange between you and Ms. Richins?
It is.
Your Honor, the state moves 2-27D into evidence and to publish.
No objection.
227D is admitted. One moment. There you are.
Good morning. I'll call you when I'm going to head down. Carpooling now, then have to run home and make something cool. That's it. Leaving the school. Headed that way. Josh and Kouri. Josh like that. From Josh, hour-long ride. Kouri responds, yep. Screenshot of the distance from Kouri, and then I love you from Kouri. I love you, want to be one of my Valentines from Kouri. Gosh. Same thing, same thing. I can take a no, that's okay. This is not responding. My heart is smiling from Josh. When those 3 words come from you, it's very unique. Different than any time I've heard them before. Those feelings when coming from you bring up different feelings in me. Your love reminds me how much God loves me. It reminds me that my mom's son, I am secretly the luckiest man on the face of the earth. Gives me immense amounts of appreciation, gratitude, and honor. I wouldn't trade your love in for a million of, you name it, whatever is next best. Darling, you better believe that I'll be one of your Valentines. Will you be my Valentine tonight? I was writing this on the way to Salt Lake. I know you feel the need to apologize, but just so you know, I like to see you on phone calls and I can't see the rest, unfortunately, because it's being blocked by his name. And I love you most from Josh. The path.
Scott, can I get 2-29D, please?
Ugh, that must be torture up on the stand. Poor Scott was duped.
Look at this as they go through.
Okay.
Will you go back to the beginning, Scott?
So he's just nodding in agreement of text that he sent. I don't know why he's not verbally stating anything, but he's just nodding his head. Maybe they're not ready. They're just submitting it all into evidence.
Your Honor, I'm sorry, seeing we're frozen up again.
No problem. Let's fix it. 1 second, Mr. Grosser. The witness has the document.
Sir, did you recognize that as a February the 15th accurate depiction of a text exchange between you and Kouri Richins?
Yes.
Your Honor, the state moves 2-29D into evidence.
No objection.
2-29D is admitted.
Interesting.
Man.
Scott, can you please bring up 2-31D? Sir, is that an accurate
Yes.
depiction?
Yes.
February 19th text message?
Yes, sir.
Your Honor, the state moves 2-31D into evidence.
No objection.
2-31D is admitted.
Sir, would you like to take a break?
Mr. Grossman, not working. You need a minute or two.
I don't know what I need.
Let's just start with that. Why don't we take pause for a moment, sir, if you don't mind. Let's take a 5-minute break, please. Please rise for the jury.
Sorry.
No apologies. Please have a seat. Mr. Grossman.
Yes.
I'm going to let you take a few minutes, collect yourself. You're welcome to walk around the lobby. You are welcome to use the restroom. Do not speak to anyone, all right?
Nobody in here.
Nobody in here. In fact, I'm going to ask everybody that's in here to just sit tight for 5 minutes so we don't have any ambiguity about whether anybody is interacting with Mr. Grossman while he just takes a short break. Feel free to stretch your legs. There are going to be more questions. I just need you to be present, able to listen.
Right.
It's fine. Take 5 minutes. Don't talk to anybody. Okay?
Okay.
You go stretch your legs for a second.
I feel like I got something I want to say.
Yeah, but you're going to have to wait and just answer questions that are asked, okay?
Okay, I'm ready though.
You sure?
As
You sure you don't want to stretch your legs?
That ain't the legs that
All right.
need to stretch.
Well, I'm going to sit here for a minute,
I'm
just
cool
answer
with
an
that.
email and take a deep breath,
I'm
okay?
cool with that.
All right. After you take 5 breaths, will you line the jury back up? Thank you. It's important that you just wait for the question asked, okay?
Gotcha.
I appreciate that, sir. Bowen, whenever they're lined up, you can bring them. Thank you, sir. Folks, please have a seat. Thank you. All right, have a seat. Mr. Grossman, you're still under oath.
Okay.
Very good. Mr. Bloodworth, your next question, please.
Thank you, Your Honor. Scott, can I get 2-32D, please?
Just glance at these as they go by. Mr. Bloodworth will have a question for you.
Still going through. Thanks for bearing with me. I'm still learning how to do this, and also I just don't feel well today. But I want to keep learning every day and growing the channel. So even if it's not like the best content, I'm trying my best just to keep at it every day.
Sir, is this an accurate depiction of a February 23rd, 2022 text exchange between you and Ms. Richins?
Yes.
Your Honor, the state moves to admit and publish 2-32D.
No objection.
2-32D is admitted.
Scott, can we get 2-36D, please? Sir, do you recognize that as a accurate depiction of a March 2nd, 2022 text exchange between you and Ms. Richins?
Yes.
Your Honor, the state moves to admit and publish 2-36D.
No objection.
2-36D is admitted.
Scott, 2-38D, please. Sir, do you recognize this as an accurate depiction of a March 2nd, 2022 text exchange between you and Ms. Richins?
I do. I mean, obviously, I'm not gonna remember every word in there, but I'm not saying it's not. These are our texts, period. Whether I remember them all or not, but yeah.
Your Honor, the state moves to admit and publish 2-38D.
No objection.
2-38D is admitted.
Scott, can you please split screen 2-39D1 and 2-39D2? Scott, can you go to just 2-39D? Scroll through that. Oh, boy.
Eric's father there in the corner.
Sir, is that an accurate depiction of a March 3rd to March 4th, 2022 text exchange between you and Ms. Richins?
Yes.
Your Honor, the state moves 2-39D into evidence.
No objection.
2-39D is admitted.
Man, oh man.
Just pause for a minute.
Okay.
Okay, this is a long one, kind of giving you a hard time here. Oh, I don't want to keep the barcode stickers on the wine glasses. I don't want, this is 90%, so seeing and hearing a reaction, we need to pound something in something business. Oh. Wow, very interesting facts. Whoa. Turning off phone. Eric's passed away last night. No words either. Nuts. I can't do this. I am devastated. Wow. And I don't know what to say or do. I want you to be safe for everyone. What happened? Who are you with? Yeah, I might call the ambulance. Been up since then. People, family, friends still there. They think an aneurysm.
Scott, can you bring up the gift attached to that?
Wow. That's intense.
So is that an accurate moving depiction of the gift thumbnail that was attached?
Was attached to what?
The email we just looked at.
That seems like pretty. I mean, I don't know. Who sent that? Me?
We can go back to that. Scott, can you take us back to 2-39? Sir, can you see that?
I see that. Maybe I'm just mixed up on the times or dates or something.
Sure. If you bring up the gift.
If I sent that after reading what I just read on here, then I was,
Just wait for the next question.
Okay.
Is that the moving version of the thumbnail that was attached?
Right.
Your Honor, the state moves this in. What I'd like to do, I'm not sure how they got separated. I would like to mark the the text exchange as 2-39D1, the associated GIF as 2-39D2.
No objection, but could we clarify the gift was sent on March 3rd? Those texts cover both March 3rd and March 4th.
The GIF was sent, it's in the text. It was sent at 7:22 p.m., March the 3rd, 2022.
Okay. 2-39D1 and D2 are admitted. What order would you like to publish things in?
Your Honor, let's please publish D1 and then we'll publish D2 at the end.
Okay. Scott, let me know when you're ready.
Yeah, we've walked through D1.
My apologies.
D1.
Okay.
So it's just publishing D2.
Okay. Do you want to show do you want to show the message at the end to provide context for the thumbnail, or do you want to go directly to D2?
Tell you what, Scott, give me D1 on the left, D2 on the right, thumbnail portion of D1 on the left.
One moment. Okay.
Thank you. Scott, can I get 2-49D?
Excuse me. Oh my goodness. Wow. Lot to enter into evidence.
Sir, is that an accurate depiction of a March 20th, 2022 text exchange between you and Miss Richins?
I believe so.
Your Honor, state moves to admit and publish 2-49D.
No objection.
2-49D is admitted and will publish now.
I don't know how you feel about that. The visitors, I feel however you feel, but without knowing, I think that I'm glad for Village. How many commas can a guy put in one sentence? I made a Harbor Freight run. And I'm going to pick up a couple Fuegos and go get busy. Not my preferred kind of busy. That place sure does look cool. It's feeling pretty there. Enough. Can't believe it. I know I wanted to go for a long time speaking French. That seems suspect. Would you mind if I ate a ton of curry tonight? From Josh. It's a lot, overwhelming, exhausting, repeating your self emotions all over again. Sounds like a good evening, I guess. Could be better. It looks so pretty. I've always wanted to go there. No French. Why would I care? Silly. I feel like it's a little out of the ordinary compared to some places I could very easily suspect wanting the exact opposite. No visitors. Nobody wanted to bother you, especially when it's got the army of heathen kids. Waiting for Ashton's protege. I just need a little time and some beers to bring out more Frenchness. I'll be spouting some wee before the night is done. Wow. Some little gift there, but I can't tell what it was. Corey asked, why French? No, it's English goofball. French Caribbean, St. Martin. Going to get you some eggs Benedict over there for sure. Huh. Yes, please. Yes, please. Can't wait. Wow. Yes, ma'am. That'd be awesome.
We can stop it there, Scott. Thanks. Scott, 2-51D.
Wow.
Sir, do you recognize that as an April 8th, 2022 text exchange between you and Ms. Richins?
Yes.
Your Honor, the state moves to admit and publish 2-51.
Oh, sorry, no objection.
2-51D is admitted.
I think I want you to be my husband one day. Wow. What date is that? April 8th. All right, April 8th. You could see yourself through my eyes. You know how much I love you. I'll love you forever.
your last one? 2-53 Delta Sky. Sir, do you recognize that as an April the 15th, 2022 text exchange between you and Ms. Richins?
Yeah, I recognize it. I didn't have time to read it all. I'm not saying that I need to. I'd like to read it later, maybe.
Okay. Your Honor, the state moves to admit 2-53D and publish.
No objection.
2-53D is admitted.
Sir, did there come a time after Eric Richins' death when you met up with Kouri?
Yes.
Do you recall the first time?
Yes.
About when was that?
I'd guess 2 weeks, 10 days, 2 weeks, something like that.
What happened when you met up with him?
I forget where we met, but we rode up into the Uinta Mountains together. Two vehicles, I think. I can't remember. We both wound up in hers, though, in her vehicle. We sat there and talked.
Did you talk about Eric?
Yes. Yeah, that was the first opportunity to really, that was the first time.
Did there come a time during that discussion that Kouri Richins asked you about killing?
Do you want me to contextualize it?
Please.
So yeah, we sat there and talked for quite a while, and I'd never seen her that way, obviously. It was a heavy conversation. And I'm not used to that with her. She's not used to being open like that. So at one point, my opinion then, probably still now, looking back, was that, she was looking for any reason. I think she was exhausted emotionally. And I think she was looking for a reason to divert the conversation away from herself, because she does that. She does that about lots of things in every normal life, And I think that's what she did. She asked me, go ahead. I'll let you ask. I know.
Sure.
But
Did she ask you a question about killing?
she did ask me yeah.
What's her did she ask?
She asked if I had ever killed anybody.
Wow.
And was that specific to killed anybody while serving in Iraq?
Right.
Did you respond?
I did.
Did she ask a follow-up question?
Yes.
Sir, what was that follow-up question?
She asked me how it made me feel or something along those lines. And then I answered her.
Whoa. Has he killed someone? I need to look that up.
I took it as not out of the normal, though, really.
Did you and Kouri Richins stay romantically involved after Eric Richins' death?
Yes.
For how long?
You'd have to look at my phones to tell me that. I'm going to guess, bless you, 6 months, maybe 8, 10. Best guess.
And then what happened?
I don't know. Just had a falling out, disagreements. Things changed after Eric passed. I mean, I don't know what to say. Things weren't the same. So I don't know if that led to us parting ways or what, but there was a lot on both of us. You know what I mean?
Understand. Thank you, sir. I don't have any further questions.
Oh, do you need to take a restroom break? May we take a restroom break? Yes. Please rise for the jury.
And I'm going to pause here for the day. Thank you, everyone, for joining, people of the future. If you stuck it out, that was a very interesting thing. I apologize. I'm not on screen. I'm not feeling well today. As you can hear, I'm congested and sneezing. I'm so sorry. But anyway, I'm also just learning how to do this. So thank you so much. And I will see you in the next one.